Hey, chat, how are you guys doing? Hope you guys are doing well. And why are we... Damn camera. You will not focus the way I need you to. You're focused on the safe, not me. There you go. There you go. Focused. Focused. And then the contrast still. I'm looking a little orange. I understand that, but it looked okay off screen. Part of the issue. So that's why. All right, guys, how's everybody doing? How's everybody doing? Oh, by the way, we did get something. Mail came in yesterday. I got to take a look. Let me go grab it, guys. I'll be right back. Hold on 1 second. All right, guys, here we go. Let's see what we got. No note. No note. And this came in on the 3rd. So here we go. First things first. Why are like what the I don't get it. I don't get this chat. You guys is unmuted now, so I don't know what you guys are saying. It's a portable bottle warmer. I don't know why I need one, but okay. Thank you. Not really sure what that's for, but all right. All right. Um uh Thank you. I guess. I don't know what I'm going to do with this. All right. And then no, we're not having a baby, so I'm really confused about that. Yeah, so all right. Keep the pee bottles warm. That'd be funny. Hey Kurt, how you doing? What is happening? I've been doing legal research on the Lanham Act today. Exciting stuff. It can be. The Lanham Act, the Copyright Act is very interesting. Hope you're doing well, guys. Kurt, a friend of the show. Hope he's doing well. I got to see Kurt last night when we were on with Danny on for the memorial stream for Legal Vices. So that was a nice time. Very nice time overall. And this, very interesting. I do like this. Actually, I think this has got some use here. It is a multivitamin for Shih Tzus. Let's see if we can give Clyde one. It's not CBD based, but I'm sure Clyde's gonna like them. Let me see here. Because Clyde is part Shih Tzu. If you guys go, and if you're on locals at potentiallycriminal.locals.com, we did the Embark, which is 23andMe for dogs. And Clyde is majority Shih Tzu and, Lhasa Apso and Chow Chow. So there we go. Very well sealed. Holy shit. Okay. Hey, Clyde. Here, buddy. You want a treat? There you go. Eat some vitamins. Help you in your past. So whoever got this, yeah, guys, there's no note. So thank you. Thank you very much. Shugi says, I've tried to restream an anti-Trump certification rally, and you choose to go live now. Well, hey, remember the big one's going to be on Monday in chat. We are covering that. We will cover the certification on Monday. That's going to be a fun time. I will tell you. That's going to be fun. It'll be fun in the sun. So thank you to whoever sent those. I don't know who did, but thank you guys. I appreciate it. Okay. So let's get back to what we're dealing with tonight, guys. We are dealing with the case of Guns Save Lives Incorporated versus Kwame Raoul. This is a challenge to the Illinois Firearms Owners Identification Card, the FOID. And believe it or not, in Illinois, you need to have an ID card before you can even go out and purchase a firearm. So that is, one of the challenges here. And there are a lot of cases that are being challenged throughout the state. And Kwame Raoul is the Attorney General for the state of Illinois. So that is where we're going here. So let's see here. The government knows exactly what they're feeding the Haitians. Well, we cover it live from the Capitol? No, but it should be broadcast. I'm sure C-SPAN will cover it. So. Oh, well, good. We can do that, Kurt. We'll co-stream it. That sounds like fun. Yes, we will cover it live. We're going to do it live, chat. We'll do it live. So, but anyways, guys, getting back to the case, this was filed many years ago. This has been an ongoing case. It's been going back and forth through the courts in Illinois, and it's been a challenge. They challenged it at the county court level. They got an injunction. They got denied. They appealed it up to the intermediate courts. The intermediate courts said, we're not going to grant it, but we're going to send it back down and let you guys sort it out. And they mainly said the injunction's not important because the status quo has been around since 1968 of having the card. So it's been back down. It's been working its way through the courts. There have been motions filed, motions to dismiss. There have been summary judgment motions filed. The court granted the state the defendant's summary judgment motion, denied the plaintiff's summary judgment motion, and now there's an appeal of this, and this is a pretty good oral argument here. So that will be what we're going to do. And hold on one second, guys, real quick. Yeah, guys, I did want to bring up something. I know some of you guys, when we were in the chat last night, when you are doing kind of like this multi-streaming thing, like we were all doing. So when I'm in StreamYard and it's not my stream, there's like a little button at the top corner of my screen up here that says stream to your own audience. And I can click on that. So I'm part of Danny's stream, but also it's broadcasting on my channel. When you guys are in chat and you guys type shit in, other people could see the comments. So that's why you heard me once in a while, guys, saying like, guys, knock it off. And 2.0 was helping to try to crack down a little bit. Just because it's technically not our stream and other people get to see the comments. So it's more of the idea of, like I tell you guys, when we're on with someone else, we can't go shit in their house. We try to be respectable. So that's why we were doing that. And I just want to make sure you guys know that's the only reason why I was doing it. And then I didn't realize 2.0 decided to help out, and I appreciate you did. But that's why we were saying and acting the way we were acting. I know some people got a timeout or two. You guys, the timeout should go away, but that's why that happened. So, and ultimately, guys, like I said, it's ultimately because of what it was for last night. It was a remembrance to Jeff. It was his kind of like a memorial stream, a little bit of a wake, celebrating him, talking about him, having a good time. You know, that's why I appreciate you guys doing what you did, and you guys were great overall. It's the reason why we didn't have super chats. If you guys want to donate to Jeff's Give Send Go. But also why we just, you know, just were civil, we were nice, and, you know, did it that way. Is there a way to restream, keep the chat to ourselves? No. Is you can shit and Sean said, well, we have dirt floors here, so you guys really aren't hurting anything. So Jim says Jeff was a great guy. He was probably the best of all of us, the best out of all of us. So Runkle, hey, Runkle, how you doing? All right, guys, so we're going to get started here. This is the oral arguments that we're going to get into here, so let's get going. These are actually pretty good. You might think, well, why are these important? Well, this is something that's going to be working its way through the courts, and we might be dealing with might hear a lot more about this going forward. And these were just cited a couple weeks ago, and it's neat because the Illinois appellate courts, and as these smaller courts do, they have their own Facebooks, YouTubes, which is very helpful for us to listen to things here. And there we go. Couldn't find a thing here. So it's a 3-judge panel, and they are going to do this they're going to do this video. So here we go.
Yes.
This is the bailiff. Thank you. I'm just waiting for Miss Notes to connect to audio. Good afternoon, Miss Notes. This is the bailiff. Can you hear me okay?
Can you hear and see me?
Yeah, you're a little.
This is kind of funny. She's like so far in the back, she's blurred out the backgrounds. But there you go. And guys, if you're wondering why do they have the same background, I'm sure the court has told them we want you to use this background.
You're a little far from. There you go.
There we go.
Thank you. Before we begin, I'd like to note the oral argument is being recorded by the court and live streamed for public access. Any audio or video recording of the argument by any person unaffiliated with the court is prohibited. The Fourth District Appellate Court of the State of Illinois has now convened. The Honorable Peter C. Kavanaugh presiding.
Also, guys, I do want to say really quick, hat tip to Stabby. He is the one who provided this to me. It is very, very good quality. So thank you, Stabby. Give him all the ass pats. And Runkle, hope you're doing well, buddy. Good to see you again. So here we go.
Thank you. Good afternoon. We'll call 4-23-0662 Gun Save Lives versus Rami Raoul et al. Counsel for the appellant, please state your name for the record.
Clark Hildebrand for plaintiff appellant Gun Save Life.
The appellee.
Good afternoon. My name is Jane Eleanor Notes for the defendant appellee, the director of the Illinois State Police.
Thank you, Mr. Hildebrand. You may proceed.
Thank you, Your Honor. May it please the court, Clark Hildebrand for plaintiff appellant Gun Save Life. The FOID Act prohibits law-abiding Illinois residents from possessing all firearms anywhere in the state of Illinois. To avoid becoming a criminal, such citizens must submit an application and pay the state for the privilege of exercising their fundamental right to keep and bear arms even in the home, where the right to possess firearms is most acute. The state admits the FOID Act implicates the Second Amendment's plain text, which is step 1 of Bruin. That triggers the state's burden to establish a historical tradition of comparable firearm regulation. The state cannot carry this burden. Illinois' law would have been an outlier in 1791 and at any other time in our nation's history.
And now remember, chat, this case initially was filed back in 2020. Well, remember, we didn't have Bruin back then. But as things have gone on, Bruin is now in play. So Bruin has to be considered, you know, as does not only just Bruin, but also the holding in Rahimi. So we have to go back to, and as he's stating here, the game has changed since the last time this court dealt with it. It's changed a lot.
Welcome to court's questions. And if they're not, I'll proceed first to the state's argument that Bruin somehow allows this shall issue possession law to somehow bypass Bruin's two-step approach.
Mr. Hildebrand, before you begin, just a point of clarification. Do you agree with the state that the FOID Act is a a shall issue licensing regime?
The FOID Act is a shall issue possession licensing law. So
Okay.
yes, that's Your Honor. It's not. It is not, however, a shall issue carry law. Illinois is one of only 2 states that has a law that sweeps so broadly that it applies to require a license simply to possess a firearm in one's home. Illinois, of course, is a separate licensing system that applies to concealed carry in public and bans open carry of firearms.
The clarification that I was looking for was just simply as to whether it was a shall issue versus a may issue licensing regime.
So yes, Your Honor, this is.
Yes, real quick, guys. This is going to be your time. They're counting down time here. And since he's going first, he gets a save. He gets a reserved time for a rebuttal. So, yes, this is his time. And if you guys noticed here, this is 58 total minutes. So there's not a lot of, this isn't a long oral argument. This is going to be a very long stream anyway. There's not a ton of break in there. So, yes, that's his timer running. And that way he gets to know what's going on.
A shall issue regime. We want to be clear, it's a shall issue possession licensing regime. It's not like, yeah. And so for footnote 9 of Bruin is where the state points to say that somehow we can bypass the 2-step approach that Bruin's holding requires. Bruin simply set aside for another day the question of whether a shall issue concealed carry licensing law would be constitutional. It did not opine one way or another, and that was not essential to the court's holding. It's thus obiter dictum and is not binding anyway. And cases this court could look to on that issue would be People v. Lightheart from the Illinois Supreme Court last year, or Harms v. Sprague from this court in 1983, and that opinion was affirmed by the Illinois Supreme Court the following year. The petitioners in Bruin expressly declined to challenge the constitutionality of shall issue carry laws, as Justice Kavanaugh's concurrence notes, for example. But even assuming arguendo that footnote 9 is binding, which we don't accept, the footnote does not apply to shall issue possession licensing laws. At least for carry licensing laws, the state could point to surety laws or fray laws that apply out for public carry. But those sorts of laws did not reach into the home to ban the possession of firearms being possessed in the home there. And so even if footnote 9 were to somehow resolve that issue for a shall issue carry laws, it wouldn't apply there.
Moreover, and if I understand correctly, your argument, it's that you have to get to step 2 of Bruin no matter what. There is no skipping step 2, such as what the Fourth Circuit did in Maryland shall issue.
Yes, Your Honor, that's correct. You can't skip step 1. Step 1 simply, as in Rahimi, it looks at whether or not the firearm regulation implicates the plain text of the Second Amendment right to keep and bear arms. Possessing a firearm is squarely, here even in the home, is squarely within the plain text of the Second Amendment. And that's all that the first step in Bruin's test requires. So we have to get to the second test of Bruin. And that's exactly how the Supreme Court approached it in Rahimi, just because the law dealt with domestic violence abusers, that didn't allow the law to somehow bypass the 2-step approach. You had to get to the second step and see whether or not they were historical comparators. And here there are not any historical comparators from 1791 or even from a later time period that are comparable to a law that puts a precondition on exercising the Second Amendment right at all, of exercising the right to possess a firearm in the home. The laws that the state cites simply aren't comparable. It focuses on, for example, loyalty oath laws or laws that disarmed Catholics. But as the Supreme Court noted in Rahimi, by the time of the Second Amendment's ratification in 1791, the Second Amendment and early state constitutions made clear that you can't disarm political opponents or religious minorities. These sort of laws are not well established in our nation's history and are no basis for upholding the FOID Act. After that, the state gets into laws that more post-state the generation that ratified the Second Amendment. We get into surety laws, for example, but surety laws only apply to those who were demonstrated threats of causing harm to others out in public. They did not apply as a broad prophylactic measure to every citizen to require them to affirmatively go out and prove to the government that they were not a felon or mentally ill or anything.
So chat real quick, wanted to touch on this. You heard him mention surety laws, and there were laws that you had to post a bond or a surety if you were engaged in certain types of risky conduct or you have been proven to be risky previously. That's where these many states and, especially like California and New York will try to say, oh, well, that's how we can make insurance policies mandatory. They weren't mandatory for everybody. They were only mandatory for people engaged in more dangerous things or people who had done really dangerous or irresponsible stuff going forward, and they had a history of doing it. So, for example, if you had a firearm or if you had a cannon and you blew up half the neighborhood, okay, well, you can own your cannon, but now you got to put money up because we don't trust you not to hurt anybody or destroy someone's house. There was no requirement that everybody had to do it. Most of the time, you were given the benefit of the doubt until you fucked up. And then also, you heard him say that, Catholics couldn't own guns. That was a very common thing. Slaves couldn't own guns. Indians couldn't own guns. Catholics, believe it or not, Catholics were a very persecuted religion in the colonies because, especially in New England, because they were Puritan and they were Protestant. You get to Maryland, and Maryland was like a Catholic haven. That's why Maryland has a very rich Catholic heritage. And then as you get farther south into the colonies of like North Carolina, South Carolina, well, those have their namesake is more for the French monarchy. You have a bigger Catholic base. You get into Georgia, it's there too. So there is, that's why you're hearing about that. Catholics were heavily persecuted against for a long time, even after the revolution. But yes, at the lead up to the revolution, it wasn't uncommon for Catholics to bar the use of arms, or at least there were laws implementing it.
Like that. Other than that, the state points to laws such as laws enacted by southern states in the 1850s, 1860s, even a post-Reconstruction law enacted by Florida. And these laws, again, as Rahimi and Bruin made clear, we can't look to laws passed by Confederates that, as for example, the Florida law was only applied to disarm racial minorities in Florida. And even those laws do not reach as broadly as the FOID Act does, which applies to every firearm possessed anywhere in the state of Illinois. The Florida law, for example, only applied to repeating rifles. But again, that's a law from 1893, well post-dates 1791, which is the relevant period of time. But even if this court thought 1868 were the relevant time period, those sort of post-Reconstruction racially based laws are no support for upholding the FOID Act.
Mr. Hildebrand, I'd like to ask you a hypothetical, and I promise I won't monopolize the questioning here. I just want to get this out while you have time. I want you to assume a licensing law like Illinois' FOID Act, and I'm going to simplify it drastically so that we can hone in on the particular criteria here, and then the test that you would employ. But this hypothetical law is like the Illinois FOID Act. It requires individuals, in order to acquire or possess firearms, to have a license. They have to apply for the license, and the application carries with it a $10 application fee, and it consists solely of a certification that the individual is not a convicted felon. They certify that, send in their $10 application fee, and then within 30 days, they shall be issued the license. Now, under the U.S. Supreme Court cases here, just taking the cases that you've identified, and I think you say Bruin is sets forth the framework. Take us through
That was weird. I don't know why
the analysis of that hypothetical law.
Of course, Your Honor, I'll try to address the hypothetical as best I understand it here. So we would approach the law first it's a firearm regulation. We approach step one of Bruin, and it sounds like the law applies to possessing a firearm that is squarely within the text of the Second Amendment. So step one is satisfied. Step two comes about where the state would have to present laws that it says are historical comparators. I think you have to look at laws at the time of the Second Amendment's ratification in 1791, and immediately right there to show that it's comparable to that. I don't think that a law that required every Illinois citizen to certify to the government that he or she is not a felon before that individual can possess a firearm would be constitutional. And I don't think there are historical comparators to that. Just as you wouldn't require, for example, someone to obtain a license from the government to pray with their family in the home, or to post an unpopular opinion on Twitter or X or whatever it's called these days. There's no historical tradition of doing so.
So
I
that
think
law would be unconstitutional.
yes, Your Honor. I think such a law would be unconstitutional. And again, we
How
have
do
to
you
look
square
at
that? How do you square that then with what Heller says when it says that nothing in Heller should be taken to cast doubt on longstanding prohibitions on the possession of firearms by felons? Why? What was Heller looking at then?
So I think what Heller was referring to, and at first I don't think we should read too much into dicta from Heller, because even with statements like that, when we get to Rahimi, you still have to go through that two-step process for individuals subject to domestic violence restraining orders, for example, or the Seventh Circuit when it was approached with the issue of prohibitions on felons possessing firearms in Atkinson, which is the case from last year. So I think what the Supreme Court was looking at are laws that prohibit and criminalize felons possessing firearms. Those impose criminal punishments and make it a crime for a felon to possess a firearm. We see those laws. Illinois has its own separate law that prohibits felons from possessing firearms. The federal government does as well. And so those sorts of laws create criminal prohibitions that apply just to felons. Those are individuals who have already been convicted of a felony. This law, in contrast, applies to all Illinois law-abiding residents, as in the Illinois Supreme Court's decisions in Burns and in Aguilar. There is no element that limits it to just applying to felons. And it sounds like for the hypothetical law that you described, there's nothing that limits that only felons have to go out and obtain such a license. So it might be a different situation if it's a law applied only to felons. But as you described it, the law applies generally to the law-abiding public. And I think it beggars belief to think that the FOID Act is what is going to stop a felon who's intent on possessing a firearm in violation of Illinois' separate prohibition on possessing firearms, that the FOID Act is somehow going to be what stops them. 48 other states, again, the federal government has a prohibition on felons possessing firearms, and I believe pretty much all other states have their own laws prohibiting felons possessing firearms. But 48 of the other 50 states, of the other 49 states, don't have a law like the FOID Act that completely requires all law-abiding citizens to go out and affirmatively prove to the government that the individual is not a felon or mentally ill or something like that. It simply is not necessary. Of course, those sort of policy weighing arguments are not what we look at under the Bruin test. But when you're looking at historical comparators, the FOID Act simply has no historical comparator. If you're looking at things like surety laws, the U.S. Supreme Court made clear that those sort of laws, similar to the prohibition on those with domestic violence restraining orders, they only apply to those who have been found by a court to be a felon, to be a domestic violence offender. The law that you described in the FOID Act itself, they apply generally to everyone in the public. And in other areas, this just simply would not be allowed, and it's facially unconstitutional to have such a law.
And I think I know the answer to this, but if
Yeah, I do think that's a very big problem, Uncle, here. Yes. There's a difference between felons can't have guns and you need a license to a gun. And also, I think part of the issue here is, and this is something these judges will never admit to, but we see this routinely when the court's trying to shape policy. They make a statement and they make a holding, and then it gets expanded upon. Just like, and I've said this routinely, like the civil rights movement in America. It took a while to push it farther and 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 farther out. You start a little bit and then you push. The court never goes in big leaps. It's always a little hop, a little hop, little hop, little hop, little hop. They never go. So I don't think this is incongruent with Heller. They're saying, you can have things here, but they're also pointing out that you got to have some sort of ability or limitation. And yes, a felon himself can't own a gun. That's why guys in prison can't own guns. And while you're on probation or parole, you couldn't, and that would be 100% held up. But the idea of just flat out just prohibiting people, that's the issue. So, yeah, I just think this was a bit ridiculous. But also remember, Runkle, it's It's Illinois, but also these guys are being asked to overturn something that's been around for like 70 years now. Remember, judges are very risk averse. So that's how I would argue it. Do I love black people? Oh.
The Fourth Circuit of Maryland were to consider the law that I
I agree, Manny.
hypothesized
I
here,
agree.
it would seem they would take it as a first step only analysis and without need to get to the second step in terms of the historical traditions, and they would uphold that law, and that you would disagree with that analysis.
Yes, Your Honor, I would disagree with the Fourth Circuit majority there. I think Judge Richardson's dissent had it better in that case. And other courts, such as I mentioned earlier, the Seventh Circuit's opinion in Atkinson, which is addressing a law dealing with felons, so that even despite the dicta there, you still have to get and apply the holding, which is that you need this two-step test. And it may be that the state can prevail on step two by showing historical comparators, similar to how the federal government prevailed in Rahimi by showing historical comparators for those subject to domestic violence restraining orders. But you can't simply avoid the test, which is the holding of Bruin altogether. And other courts that have similarly approached that, I think we cited in Eighth Circuit decision dealing with the Minnesota law called Worth. And other courts, I think, are correct with Judge Richardson's dissent that you just can't have this end run around simply because it's a shall issue licensing system, especially here where it's a shall issue possession licensing system, which completely eliminates any ability of just law-abiding citizens to possess a firearm, even under the scenario where you'd have and I think it's the Supreme Court noted in, I think, footnote 1, maybe footnote 2 of this decision in Bruin, even for those within 43 states that have shall issue carry licensing systems, the majority of those states, I think at the time it was 25, now states like South Carolina, Florida, Louisiana have joined them. The majority of states allow some form of permitless carry, whether it's open carry or concealed carry. You don't have to have a license at all to carry in the majority of states. And in 48 of the 50 states, law-abiding citizens don't need any sort of license to possess a firearm in the home, which, as Heller noted, is where the right to keep and bear arms is most acute.
Bill Brand, could I ask a question?
Of course, Your Honor.
The reference that was made to Heller by Justice Harris related, did it not, to the historical tradition of precluding felons and people who were mentally ill from possessing firearms?
I think there is similar to Rahimi, even where you have dicta from, and that's how the Supreme Court approached it, is where you have dicta in decisions like Heller or in Bruin about his prohibitions and felons or domestic abusers possessing firearms. You still have to go through that two-step process. I think that's why.
But my point is that was already understood by the founders when the Second Amendment was enacted.
Well,
they already understood that there are certain classes of people who are and have been historically prohibited from possessing firearms, correct?
Well, here you are. This isn't applying to certain classes. This is applying to all law-abiding Illinois citizens. Felons are already prohibited from possessing firearms. So
that's the point I'm getting to, is that they're not affected by this application of the FOID Act, correct?
Correct, Your Honor. Felons are already prohibited. This law really is going to impact law-abiding Illinois citizens, and particularly possessing firearms in the home, because Illinois already prohibits, as soon as they take that firearm outside the home, if they want to carry it out in public, Illinois has a separate licensing system that applies there, and then of course they can't open carry it. So if you're going to apply how the Illinois Supreme Court approached the facial test in Burns, we're looking to where the law has an actual impact, and I think you're right, Your Honor, that the actual impact is on those law-abiding Illinois citizens, people who aren't felons or anything like that, just possessing firearms in the home, and it's squarely protected by the Second Amendment, and there's no historical tradition of doing so.
And under a Second Amendment analysis, the only people that are relevant are the people that are affected by the restriction, correct?
Yes, Your Honor, that's correct.
And in this case, under the FOID Act, it's the law-abiding citizens that are affected by the application of the Act. It doesn't necessarily affect felons, because felons are already precluded from possessing firearms, and have historically been so.
Yes, Your Honor, that's completely right there. And then I pointed out as well that the Maryland law wasn't even as broad as this here. It applies only once for purchasing a handgun. It doesn't apply to all firearms. It doesn't apply to simply possessing previously obtained firearms in the home. It's not a repeated process you have to go through to pay the state. There are all sorts of ways that the law there wasn't as broad as what we have here. Illinois is an outlier even today, but definitely historically at the relevant 1791 time period.
Can you point to, or has the state pointed to
I'm going to try it. Give me a second.
any founding era firearm regulation that's not otherwise unconstitutional by today's standards that limits conduct in a way similar to or for similar reasons as the FOID Act? Namely, it prohibits everyone from acquiring or possessing a firearm until they prove they are qualified.
The state has not done so, Your Honor. And as we previously explained, I think the closest they try to come so would be, and just continue briefly, is to be the loyalty oath laws, which again, as the Supreme Court made clear in Rahimi, those are no basis for appointing the FOID Act, and they would be unconstitutional under how the U.S. Constitution, the Second Amendment. With that, I'll reserve my time for rebuttal.
Okay, I have a question. What about
Overall, I thought he did a really good job. These judges, I think, understand that they're remember, oral arguments really aren't meant to convince them. It's more about getting points across, maybe to the other judges, as far as what questions are being asked. And there's a question here somebody asked, I'm gonna make sure I have it right. Mike says, can the judges ask questions over the allotted time? Yes, they can. They can if they have more questions. Now, generally, it doesn't go on and on and on forever, but like this judge right here at the bottom is going to ask, he's probably got a question. He's going to ask it. Time is up. So it does happen, but it's not to the same level of like it might turn into a whole thing there. But yes, judges ultimately, it's their court. So they get to do the rules how they want. But they will ask questions. Obviously, you can do it now like this. So totally happens all the time. That's not a bad question either. Runkle says he was a little nervous, but doing well in arguing the law. Yeah, but in an oral argument, sometimes you got to find your footing. Just got to hit your stride. He hit it pretty quickly. So he did all right, I think. I don't think he did bad. I don't think he did bad here. So let's see here. Did I miss anything else? Not right this second, but yeah, we're gonna keep going here, chat. We'll keep going.
about felons that are subject to potential penalties for possessing a firearm? Aren't they affected by criminal potential exposure for being a felon and then being caught in the possession of a firearm? And wouldn't they have an interest here because they could face issues with their liberty? Thus, they're impacted.
I assume the question's still directed at me. There's a separate Illinois law. Sorry. There's a separate Illinois law, and that's 720 Ill Comp Stat 5/24-1.1 that already prohibits felons from possessing firearms. They're already committing a crime. They're already prohibited by the state of Illinois from doing so, in addition to the federal prohibition on them doing that. So the only people it's really making a difference for would be those law-abiding Illinois citizens who'd otherwise have the ability to possess a firearm in the home. With that,
I guess my point is, without the FOID Card Act, there wouldn't be this other offense, so that felons' rights are affected because it puts them in a class of individual that could be prosecuted because of the FOID Card Act and their actions in relation to that.
I think you're right. This other statute would exist regards to the FOID Act. It prohibits simply possessing a firearm. It doesn't matter. Even if you take out the FOID Act part, they cannot possess a firearm, period, in Illinois. Similar for federal law, it doesn't hinge on whether or not they have a FOID card. They are prohibited, period, from possessing a firearm in the state of Illinois. And there are systems in place to report their convictions. And Illinois also has systems which we're not considered constitutional, but Illinois has systems here like firearm restraining order laws and things like that, that if a felon has a firearm, there are ways to report that and to prosecute them. They're already prohibited from possessing firearms. So the group that really makes a difference for is those law-abiding Illinois citizens. And you can't broadly target the entire Illinois population simply because you also want to impose some additional prohibition that already exists on felons. So with that, unless there are further questions, Your Honor, I'll save the rest for rebuttal.
Thank you, counsel. Thank you for your explanation. Any further questions? Ms. Notes?
Thank you.
Thank you, Your Honor. Good afternoon. Again, Jane Eleanor Notes on behalf of the defendant.
Overall, chat, overall, I think he did pretty good. I think he did a good job here. Do I think the courts are ultimately going to uphold this? No, I think they're going to. I think the Supreme Court's going to have to get involved. But for now, yeah, they did a good job. They did a good job.
Appellee, the director of the Illinois State Police. This court should affirm the circuit court's judgment rejecting plaintiff's Second Amendment challenge to the FOID Act for 3 reasons. First, plaintiff brought a facial challenge, which means that plaintiff must show that there is no set of circumstances in which the FOID Act is constitutional. Plaintiff cannot do this because there clearly are constitutional applications of the Act. Neither the Act simply. Yes, Your Honor.
Do we not start with first determining whether the conduct that's sought to be affected falls within the text of the Second Amendment?
Certainly, Your Honor. If Your Honor wants to get at this through step 1 of the Bruin test, Your Honor.
Okay, then let me ask this question. Are you saying
Sure.
then we just completely avoid the 2-step process of Bruin?
No, not at all, Your Honor.
Okay.
My point was simply that under the framework that we set forth in Rahimi, the Supreme Court's most recent discussion of this topic, Rahimi made clear that Second Amendment challenges are subject to the same traditional facial standard, and that standard requires a showing that there is no set of circumstances in which the act would be constitutional. And here, plaintiff cannot show that there is no set of circumstances in which the act would be constitutional.
Again, it seems like you're putting the cart before the horse. Don't we first have to determine whether the conduct that's sought to be regulated falls within the textual language of the Second Amendment?
Certainly, Your Honor. I'm happy to move on to that point. And our position here is consistent with the Fourth Circuit's recent en banc decision in Maryland shall issue versus Moore, which
Okay, so let me ask this question. Is it the state's position that the conduct affected by the FOID Act meets the first test of Bruin?
Our position is that we rely on Bruin's discussion of shall issue licensing laws. And in that discussion.
Let me back up. My question is, does the acquisition and possession of firearms fall within the text of the Second Amendment?
Your Honor, I certainly agree that the possession of firearms would fall within the text of the Second Amendment, but that's not what the FOID Act prohibits. What the FOID Act prohibits is possession without a license.
I'm still back on what the text of the Second Amendment covers. Does the text of the Second Amendment cover the acquisition and possession of firearms?
The text of the Second Amendment, I don't mean to fight Your Honor's question, but at issue here is what the FOID Act actually prohibits, and what the Act prohibits is possession without a license.
Counsel, before we can determine what it prohibits, we first have to determine whether there's even a constitutional question to begin with, don't we?
And our argument would be if that this case can be decided at the first step of the Bruin analysis, exactly how the Fourth Circuit decided.
But that's not my question. I realize you're doing your best to avoid answering the question, but it's a very simple question.
Chat. This isn't good. Hey, Eric, how you doing? This is not good. Oh, no. Oh, no, Jane. Jane, you ignorant slut. You know, she's just saying it doesn't matter. And the judge saying pretend it does matter. And she apparently is refusing to acknowledge the what if you didn't eat breakfast today argument. She's refusing it completely. This is not good. This is not good. Uh-oh. Oh no, chat. Yes, I know. This is where it gets good, chat. Here we go.
Does the Second Amendment cover the acquisition and possession of firearms? Period.
Yes, certainly the possession of firearms is within the scope of the Second Amendment.
It doesn't cover the acquisition of firearms?
The acquisition of firearms is within the scope of the Second Amendment.
Okay, so we got that part done.
Mm-hmm.
Once we determine that the conduct is covered within the text of the Second Amendment, we then have a presumption that any regulation or restriction by government is unconstitutional, correct?
That is correct, but we do not
Okay,
concede
hang
that
on.
the possession
I'm
of
not asking
firearms.
you what
Okay.
you concede. I'm not
Okay.
asking what you concede. I'm taking you through a process here that actually, if you didn't fight it, it would go much faster. So once we've determined that it's covered within the text, next we then move on to, there's a presumption that any restriction or regulation is unconstitutional. It then becomes the government's burden to establish both the historical tradition. Let me back up. It becomes the government's burden to establish that we have a historical tradition consistent with that regulation, correct?
Yes, I agree. That's a correct statement of the Bruin test. Yes.
What historical or founding era firearm regulation that you've referenced so far in your briefs that isn't otherwise unconstitutional by today's standards limits conduct in the way that the FOID Act does, in that it prohibits everyone from acquiring or possessing a firearm until they prove they are qualified?
So we identified two types of historical laws. The first were historical laws that preemptively disarmed categories of people based upon their perceived dangerousness at the time. This included laws that disarmed felons and the mentally ill, as well as laws that disarmed people who declined to swear loyalty oaths. We also
understand that laws that are now unconstitutional, we surely can't rely on to find a certain regulation constitutional, can you?
Well, I guess I push back on that idea. First of all, laws that disarm felons and the mentally ill are not unconstitutional.
No, that's not
The
what I'm
Supreme
talking
Court
about.
has
And
repeatedly
Counsel,
stated that
honestly,
they are
you know that's not what
constitutional.
I was talking about.
But with respect to loyalty oaths, I guess I would push back on the idea that they are out.
I mean, Chad, just watch this judge in the middle. Watch this judge in the middle too.
The court has repeatedly stated that they are
constitutional. That's not what I was talking about.
But with respect to loyalty oaths, I guess
that's not good. She's already. Here's the thing, guys. You have to answer the tough questions. You have to answer the tough questions. You answer the best you can. Just completely ignoring them doesn't help you, because the judge he's not forgetting about it. He's not forgetting about it. You have to, you got to bite the bullet sometimes. You argue the fact you're losing this position with them, and you acknowledge it and you move on. If you keep fighting it, it's only going to make it worse. If you scream, it'll only make it harder for you. It's like, just accept it and move along.
I would push back on the idea that they are out, because what Bruin teaches is that you look at the history at the time. Now, to be sure, today, the governments would not disarm people based upon a decision, not to swear a loyalty oath. But what that historical tradition stands for is that there was a tradition of governments disarming people based upon indicia of dangerousness. And while we might disagree about what constitutes dangerousness today, that doesn't change the historical tradition.
Until they were required to make the oath, there was no prohibition against their possession of a firearm, correct?
Until they require, it is correct that they were disarmed based upon their decision not to take a loyalty oath, which was deemed to be an indicia of dangerousness.
Because
yes.
Prior to that, it was readily understood that everyone had the right to possess firearms, other than those people who have for a long time been historically prohibited: felons, people who are mentally ill.
Well, and exactly. And the FOID Act here is simply a mechanism for identifying those people that the government has deemed to be dangerous and therefore at risk of misusing firearms. I mean, plaintiff's argument is essentially that the government cannot impose a burden, no matter how small, on a would-be firearms owner for the purpose of determining whether they are qualified to possess. And Bruin says that that is not the case. Bruin expressly approved shall issue licensing laws. It also approved mechanisms
Okay. You're trying to contend that the shall issue licensing laws that are referred to in Bruin are the same as the shall issue licensing law that FOID is, correct?
Our view is that there is no difference between, for purposes of Bruin's
Okay, wait a minute.
analysis,
If
between
they're
a
not-
license to carry and a license to
I'm
possess
having
in
a
the
really
home.
hard time because you won't answer
Sure.
the question. I understand you don't want to, but that's okay. It'll just go faster if you do. There are 43 statutes referenced in Bruin. Bruin,
This is why you don't do that, chat. He's like, look, bitch. Lady, listen. I'm trying to work with you here. We're trying to move along. You got to do it. I'm like, honey, you got to answer the question. And guys, this is the other part of the issue. If he's not going to, he's trying to tell you, if you just answer it, I can move on. And otherwise, look at this. Like, she burning daylight, guys. She burning daylight while she's doing this. She wants to argue and wants to fight. You know, as Chris Berman said, tick, 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 tick. The clock is just burning off, man. You eat the bullet and move along. Bite the bullet and move along. You got to take the L sometimes in life. So.
expressly indicates how it is limiting its findings. Those 43 statutes referenced in footnote 1 that are then referenced in footnote 9 are all public carry statutes, correct?
They are, but Bruin also makes the point that there is no difference for purposes of the Second Amendment protection between possession in the home and public carry. Bruin makes
But
the
what you
point-
want to do is you want to extend that language of the right to the power of the state to regulate. And those aren't a one-to-one correlation that you're allowed to make.
Except that what
You
Bruin
can't say
says,
that because of right is you can't say that because a right is broadly protected, that the government has a commensurate right to broadly regulate it. And that's your argument, essentially.
It is.
our argument is that Bruin endorses
Uh-oh.
shall issue licensing laws, and
But it
Bruin's
only
reasoning.
referred to public carry. The subject of the case was public carry. Every statute referenced in footnote 9 is public carry. The Illinois statute that they cite is the Illinois concealed carry statute. There's absolutely no reference to the FOID Act, nor is there any reference in footnote 9 or footnote 1 listing all the various statutes to any possession regulation. They are all related to public carry, and public carry has also historically been dealt with in a different fashion than the individual private possession of firearms, has it not?
In some cases it has, but in some cases it hasn't. We identified I guess I'd like to make two points if I may. First, with respect to Bruin was a case about public carry, but Bruin's reasoning also hinged on the proposition that there is no difference for purposes of the Second Amendment between public carry and private possession. Bruin explained that the text of the Second Amendment protects the right to keep and bear arms, and
But
it does not elevate the right to keep arms above the right to bear arms.
That's the right that is being protected. It's not the power that the government has to regulate. You take it out of context. It has nothing to do with the ability or power of the government or the extent to which the government can regulate the right. It simply is referenced in terms of the broad nature of the right itself.
Except though we know from Rahimi that the government can regulate to seek to keep firearms out of the hands of people who have been identified as dangerous and therefore likely to misuse them.
Sure.
And my point is simply that proposition applies equally to public carry and to at-home possession.
But
Because
in each instance, okay, go ahead.
if somebody is at risk of misusing firearms, they're going to be at risk of misusing firearms simply by virtue of acquiring and possessing firearms. It isn't solely when they take those firearms into public. And then if I could just add, we know that Bruin didn't elevate the right to keep arms above the right to bear arms, because that would be inconsistent with not only the text of the Second Amendment, it would also be inconsistent with the amendment's purpose, which was to allow people to protect themselves in cases of armed confrontation. And somebody is equally likely, to need to defend themselves in public as in private. So for all these reasons,
it was simply the codification of a pre-existing right, and the pre-existing right was the right of all persons other than those historically otherwise prohibited, to possess firearms.
Yes, that's very true, but also in conjunction with the historical tradition, which Bruin's footnote 9 talks about, and which the court elaborated on in Rahimi, of giving the government the ability to use a variety of mechanisms to confirm that the people who possess firearms are not likely to misuse them. And that is
No,
all.
Rahimi did not. No, I strongly disagree with that assertion. Rahimi did not reference the individual right to possess firearms, other than those circumstances in which that person had been brought to the attention of the authorities because of some either dangerous behavior or some circumstance that put them before the court. It didn't just blanketly agree that you can regulate the possession of firearms for all lawful citizens. In fact, it excluded lawful citizens and said you can regulate those circumstances where that person has, for whatever reason, done something or obtained a certain status that puts them in a position where we have to regulate them, either through their behavior, threats, conduct, whatever. But it said nothing about just the benign possession of firearms by law-abiding citizens being subject to that same level of regulation. And if you say Rahimi does say that, I will be more than glad to listen to you cite the provision in Rahimi that says that.
So I certainly agree that unlike Bruin, which actually did address shall issue licensing laws, Rahimi was not dealing.
Only within the context of public carry.
Can I jump in here? What was Bruin about?
Uh-oh, here, guys. I love this when Judge Harris comes in here. This is the perfect timing. Here we go. Just listen to this. Listen to this. They are so angry. And like she can't concede any ground here. Which, guys, when you're in an argument, you have to be able to do this. Concede the ground, and then you can still make your point. And you could try to distinguish it. You could try to contest it. But just saying, no, fuck you, Judge, you're wrong. You're never going to win. At that point, you've lost. You could say, you know what, Judge? That's correct, but here's why it's different. Here's why you should think differently. You don't just go, la, fuck you. Like, this is not how you get it. You can't dig in like that. You don't have to die on the hill. You don't have to die on the hill here. You don't have to die on the hill here. So, and even when you're arguing in a losing position or when that's not popular, there are ways you can do it. This is almost like she's got ideological capture personally as well as professionally. So I mean, that's kind of the way it feels to me, at least.
Laws. Rahimi was not dealing.
Only within the context of public carry.
Can I jump in here? What was Bruin about? Wasn't it about public carry, counsel?
Yes, of course. Bruin was about a may issue public carry law. And in the course of discussing the constitutionality of that law and concluding that it was unconstitutional, Bruin set forth a standard for addressing shall issue laws. And Bruin held that these laws are constitutional so long as they are not put towards abusive ends, such as through lengthy wait times and exorbitant fees, neither of which describes the FOID Act. Now, as your honors have pointed out, at issue specifically in Bruin were public carry laws, but the court's reasoning applies equally to at-home possession because Bruin made very clear that the right to keep and bear arms, those rights are coextensive. The right to keep arms is
clear. Counsel, the court made it clear in the both in its opinion and in the concurrences that they were only addressing shall issue licensing regimes that relate to public carry, and that's all they were addressing.
Look at her face. Look at her face. Uh-oh. Uh-oh. Yes, I mean, as much as, and you guys notice this, you're like, oh, why were they so hard on him? If the fact you're getting hammered is a good sign, The fact like you're getting asked questions is good. The fact you're getting like beleaguered though is never good. And they are just going all out on her. This isn't like they're trying to ask her questions to give her a chance to save herself. These guys are actually out to go after her. This is not looking good. This is not good. This is gonna be, and guys, if you didn't know, this is gonna be the longest 3 minutes of her life here. Here you go.
Isn't that correct?
Understood. My point is simply that the reasoning of Bruin applies equally to licenses to possess and acquire firearms. That's
Well, I think it
exactly
was
what the
Justice
Fourth
Gorsuch.
Circuit.
I think it's Justice Gorsuch who said in his concurring opinion that we need to be careful to remember that the decisions by the Supreme Court are to be addressed and considered within the confines of the facts of the case in which they're entered. Correct?
Yes, but one also has to look at the reasoning. And when the Fourth Circuit in
I'm just
Maryland
telling you
shall
what the
issue
judge
versus
who was involved in the case said. He
understood.
said only consider it within the confines of the facts of this case.
And when
You're
both
saying we've decided, you meaning we, the state, has decided that we're going to use that reasoning to justify a different shall issue regime that wasn't even discussed, addressed, or considered in Bruin. Correct?
And both the Fourth Circuit and even more recently the Second Circuit in Antonick versus James, a decision that was reached after briefing was completed in this matter, looked at Bruin, looked at the shall issue licensing laws at issue in those cases, which involved in particularly in the Fourth Circuit case, a license to acquire firearms, and held that Bruin's reasoning
Firearms
applies
in
equally.
general or pistols?
Yeah, I mean, it applied to handguns, but I
Okay.
don't understand plaintiff to be arguing here that the FOID Act is unconstitutional insofar as it applies to long guns. They're
It
arguing
applies
that
to all. It applies to all guns. They contend that it's unconstitutional because it applies to all firearms.
I don't understand them, though, to be arguing that it is unconstitutional only because it applies to all firearms and therefore would be constitutional if it were limited to handguns.
No, but
And-
that's the point. The Maryland case is different from ours because it relates to a regulation that is addressing only a particular form of firearm. FOID is not that kind of regulation. FOID prohibits the acquisition and possession of any kind of firearm or any ammunition unless and until you engage in this registration requirement, which has absolutely no historical tradition supporting it.
So I guess I disagree that there's no historical tradition. In addition to the disarmament laws, the state also presented evidence of a variety of laws that required people to provide information. May I finish my answer, Your Honor?
Please.
Okay,
Finish.
thank you, Your Honor. The state also presented evidence of a variety of historical laws that required people to provide information to the government and also to pay a tax or other cost associated with firearms ownership. That includes the militia laws, it includes the loyalty oaths, and it also includes laws requiring a certificate or payment of fee prior to possessing certain firearms.
Are there how and why identical or even similar to the FOID Act?
Well, in terms of the how, the Supreme Court made clear in Rahimi that the state can use a variety of mechanisms. So, for example, in Rahimi, the court considered going armed laws and surety laws relevantly similar, even though they were not identical to how the federal law challenged in that case works. So the
all
fact
of which require some conduct by the person, which then places them within the confines of a judicial determination that finds them to be dangerous or undesirable or whatever, and then restricts their ability to possess or carry a firearm. There are many of those same historical regulations that indicated the only thing it prohibited was them carrying it in public. It didn't prohibit them actually possessing the firearm in their home as long as they didn't take it out. So that's not anywhere near consistent with what the prohibition of the FOID Act is.
So I disagree insofar as the historical tradition the state identified included the disarmament laws, but it also included a variety of laws that required people to provide information to the government and to pay a fee or other cost associated with possessing firearms. And that is relevantly similar to the FOID Act.
Justice Kavanaugh, I know Ms. Notes is out of time. I didn't want to interrupt the exchange between Justice DeArmond and Ms. Notes, but could I ask a question?
Please.
All right. Ms. Notes, when I was asking Mr. Hillebrand questions, I posed a hypothetical. Do you recall that?
I think I took a few notes on it. So,
Well,
but
it's just simply this. It was a licensing regime that required the applicant for the license to certify that he or she had not been convicted of a felony. And I believe Mr. Hildebrand indicated that would be presumptively unconstitutional. And then based on step 2 of the Bruin test, there would be no historical tradition that could be applied to find it constitutional. Can you tell me, is just based on the Bruin test, and let's assume that footnote 9 does not serve to take it out of the 2-step process, is Mr. Hildebrand correct?
no, I disagree with that position. And even I'll put the language of Bruin to one side in footnote 9, as you've requested. The state's position would be that requiring someone to pay a modest fee and fill out a certification, which really actually isn't much more than the FOID Act does, would not implicate Second Amendment protected conduct because it would not rise to the level of an infringement. The very same reason the Fourth Circuit recently gave to uphold the Maryland shall issue law. And then even if the court got past the first step, at the second step, the state's position would be that such a law, because it seeks to identify people who are not qualified to possess firearms and therefore at risk of misusing them, would be consistent with the historical tradition. And on that, I would point the court to the reasoning of the separate concurrence in Maryland shall issue versus Moore. The judges who accepted that concurrence, they disagreed with the step 1 analysis, but they agreed that the Maryland law was constitutional under step 2.
Well, I'm trying to remember the dissent. You're talking about the dissent.
I'm talking about Judge Rushing's concurrence. She concurred in the judgment that the Maryland law was constitutional, but she would have reached that decision based on a step 2 historical analysis rather than on the step 1 textual analysis followed by the majority opinion.
Well, what was identified as the historical tradition? What was the analog?
She relied in particular on surety laws and laws that had disarmed felons and the mentally ill.
Okay. All right. Thank you.
Ms. Nolch, you've been asked a lot of questions. I'll give you just a moment to briefly sum up your position.
Thank you, Your Honor. As I began to say, there are 3 reasons why this court should affirm the judgment of the circuit court. First of all, plaintiff brought a facial challenge, which requires them to show that the law is constitutional in all applications, which they can't do. Second, their challenge is foreclosed by Bruin, which explained that states may adopt shall issue licensing laws. Third, the state presented evidence of an historical tradition of laws relevantly similar to the FOID Act, insofar as the state identified an historical tradition of states imposing conditions on firearms possession, use, and ownership in order to ensure that the people who possess firearms are not at risk of misusing them. And finally, I would point out that in the end, the plaintiff's argument reduces to a position that the government may not impose even a small burden on would-be gun ownership as part of an effort to ensure that firearms are not misused by people are not possessed by people likely to misuse them. This is not supported by Bruin's express approval of shall issue licensing laws, which included an approval of background checks and a requirement of a firearms training course. And it's also not consistent with our nation's history, which shows that governments have adopted a variety of methods as they sought to ensure that firearms are safely possessed and used. So for these reasons, we respectfully request that the circuit court's judgment be affirmed.
Thank you,
Thank you.
counsel.
Thank you, Ms. Knotts. I appreciate you putting up with my questions.
Thank you.
So, what do you guys think? Oh, I mean, remember, this is Illinois, so they might support her still, but oh boy, yeah, that was not good. That was not good at all. That was not good at all. No, that was good. All. Yeah. So why do these have to expire and you have to renew them? Yes. Yes, that is a very big issue. If it's important, why do I have to keep renewing? Oh, I'd like to think so. So let's keep going here, chat.
In rebuttal, Your Honors, first let's start with, I think we've talked about the surety laws some. Rahimi was clear, and this is at 144 SCT 1901, that those laws applied only to individuals found to threaten the physical safety of another. They did not apply to the public in general. The general public was not required to post a bond to possess firearms. In fact, the surety laws only applied to carrying those firearms out around in public. If someone thought that an individual was a threat, they had to go before a court, make a complaint, there'd be a finding, and the court could decide to require a bond. Illinois already has procedures like we don't accept they're constitutional, but they exist, such as the firearm restraining order law that would operate more similarly to that. Here, however, the law applies generally to all Illinois law-abiding citizens, and that's really the group that's impacted by the law, because there are other prohibitions that already apply to prohibit felons from possessing firearms. The state continues to rely upon unconstitutional laws, such as the loyalty oath laws, that were no longer used by even 1791. Pennsylvania, for example, rescinded its law and expressly noted, its legislature noted in the statute books, that such laws were unnecessary in times of peace. As the Supreme Court in Rahimi noted, those laws are no foundation for upholding a firearm regulation today. Then additionally, the state tries to go back to the purpose of the Second Amendment. The Second Amendment supposes that individuals retain firearms in their homes that they can then bring to serve in the military, then to fight in the American Revolutionary War. But the FOID Act operates to make it a crime for an individual to have a firearm in his home unless he first goes to the state and pays the state simply to exercise that fundamental constitutional right. As again, we noted in opening, and the state hasn't responded to, it would be facially unconstitutional for the state to require everyone to go and pay the state $10 and wait 30 days for someone to post an unpopular opinion online or to pray with one's family in the home. That would be facially unconstitutional. Under the Second Amendment, there's no historical basis for the idea that you can impose such a burden on law-abiding citizens who, again, under Burns and People v. Aguilar, those are the groups, the law-abiding citizens are those who are actually affected by the law. Further, the state mentions, I think they tried to say that we're only challenging for long arms. The FOID Act applies to all firearms, and it completely eliminates the ability to possess firearms. We don't accept the argument that shall issue carry laws would be automatically constitutional. And in fact, the Supreme Court noted in Bruin at 597 U.S. 50 that there is no historical basis for concluding that the pre-existing right enshrined in the Second Amendment permitted broad prohibitions on all forms of public carry. And there certainly is no historical tradition for the idea that the state of Illinois can criminalize all forms of possessing a firearm, which here, given the other Illinois laws that exist, we're really talking about law-abiding citizens possessing firearms in the home. So if there are no, sorry.
I do have a question. Ms. Knotts pointed out that the requirements of FOID are a minimal intrusion on someone's Second Amendment right. Does that matter?
Any intrusion, first of all, I don't think it's minimal. You're making someone a criminal if you don't comply with the FOID Act, and making them go through a process that is the Second Amendment does not allow to obtain that. But for the first step of Bruin doesn't weigh whether or not the burden is minimal or extreme. Here, as the state seems to concede, there is an infringement on the with the plain text. The Second Amendment allows the right to keep and bear arms, which includes the right to possess firearms. Even if the state thinks that that infringement is somehow minimal, the idea that you're threatening all citizens that they have to pay money to the government or they become a criminal to exercise a fundamental right, even if that were minimal, which we don't accept, that makes no difference in the Bruin Step 1. Even a minimal intrusion on the right to keep and bear arms satisfies Bruin Step 1, and then we have to go to Bruin Step 2 to see whether there's a historical basis for that. And here, there is no historical basis for it. The only, and just briefly, I'll wrap up, Your Honor, the only licensing law, the only licensing law they referenced in their briefing before the 20th century is that 1893 Florida licensing law, which was racially applied and only applied to repeating rifles. there simply is no historical tradition of such a broad-based licensing law applying to all forms of law-abiding citizens possessing firearms. And so for those reasons, we urge the court to reverse the decision of the circuit court below. Thank you, Your
Any
Honors.
further questions from the panel?
No. Thank you, counsel.
Okay. Thank you, counsel. Thank you both. The court will take this matter under advisement and now is in recess.
All right, chat. There you go. Ooh. Ooh. That was rough. That was rough. Ugh. That was not a very good oral argument for the state. And yeah, guys, I'd already watched it before. There's Stabby recommended to me, and I watched it, and I was like, oh my God, you guys, we have to watch this. It is really good. And like I said, it's good. It's good. But this is an example of why, if you have a bad argument, you got to accept it and move along. I mean, these judges were basically hinting, like, we can't ignore Bruin. We can't ignore Rahimi. Like, how do we, like, what's your recommendation here? And she's saying, ignore it. And he's like, I can't do that. So it was very, very interesting to see that. It's very interesting to see that go forward that way. So let's get caught up on what we've got here. Let's get to some of these comments real quick. Mad Rhetoric saying, sorry I can't super chat this. I owe you one. You don't have to. I mean, you put a comment out. I tried to look at them if I can. Freedom of speech is curtailed on threats. Has freedom of religion ever been so scrutinized? I mean, like, there were, old laws in the colonial era, like I said, of, Catholics were heavily prosecuted. I mean, there have been a lot of things of that. Like Rhode Island was originally known as Rogues Island. They were people who broke away from the Puritans. There's a bit of that happening, religious persecution in American history, but not lately. Not lately. I mean, you could look at COVID and argue it is, but other than that, not really. Let's go, Brandon. How you doing? I hope you're doing well. Says, is it just my phone or did YouTube put a fatwa on Sean's head? I don't know. Maybe both. MLS, making life simple. David, hello. How are you doing? Saying, that one joke still hasn't landed well. I repent. Let me out of jail. I'll eat the dirt floors clean with added proof of Clyde, of course. Well, like I said, guys, just there was the issue about the time and place last night, chat. Time and place. Kitchen Knife Rescue said, I would love to see a collab with Runkle on the topic of Cody Wilson in the firearms case. Yes. Well, let's say I know Runkle's been covering it, I've been covering it, and we may do something together coming up here. Should be a lot of, we could do something. I enjoy having Runkle on. He enjoys having me on. We get along great. So yeah, something soon. Also, Runkle, if you're still here, hope you figured out your dinner because I saw you were trying to figure that out. Gigo Mango Fanta for $5 doodles is saying, love the tribute stream to Jeff. Good stuff and rip to a real one. Are you considering hopping on the Keno Casino to cover recent Baldo news or not? I don't know if Worski PPP have not reached out to me, and I'll double check real quick because I know it's coming up. But I don't think, if they message me, sure, but I'm not gonna, I don't ingratiate myself or impose upon other people. But yeah, if they had questions, certainly I try to answer them. Cheryl Morin is a new member. Thank you, Cheryl. I appreciate that. Or is it Morin? Thank you very much for being here. I appreciate your support. And Whiskey 77 has been a member for 7 months, saying, Sir Potential, leader of the armies. Yes, I saw that as well. So riddle me this from the Wolfbane. If a background check is required to purchase a firearm, which will find out if you are a felon, then why have the flipping card to begin with? Yeah, I mean, I don't disagree with you. I mean, it is what it is, man. It is what it is. It is what it is. American Legend is a new member. Thank you for the support and your generosity. I appreciate it, man. Thank you very, very much. And then Runts Rants on the soapbox Remember, chat, there's 4 boxes: the soap box, the ballot box, the jury box, and the cartridge box. He says, I live in Illinois. I'm sorry. She says, I live in Illinois. My husband owned a handgun and had a firearms owner ID card. When he died, I'm sorry to hear that. I had to apply for a firearms owner ID card or immediately sell the gun through a registered state agent. I just sent my renewal application, 60 days for waiting. Absolutely obnoxious. Once you've got it, it should be good until they revoke it. Jefferson Post says, I didn't think I was going to get home and turn on YouTube in time to see a woman getting the Ike Turner treatment in court. Pretty much. That was not a good one. Valhalla Waits, how you doing, man? He says, shall not be infringed. All gun laws are unconstitutional. I agree. All guns are unconstitutional, and most of them are racist in origin. Valhalla Waits, member for 3 months, says, shall not. Bish. Valhalla, thanks for the support. I appreciate it. Arson investigator for 1999. And he says, this woman is the state's biatch. Yes, she is being sent out there, but generally people who are in these positions do have some ideological agreements with the arguments they are making. So this isn't that much of a burden for her to bear. And then Jefferson Post, he says the amendment's purpose was to limit the government. Yes, it is what's called it's a limitation on government authority. It's not it's merely an acknowledgement of the person's rights against the government. It is not a granting of rights. And then Bushmaster 937 gifted 5 subs. Starting the new year off with more H-1B green visas. Also praying the gray away, chat. We are getting rid of the grays. We are making this a green city. So grays, keep moving. There's no room for you here. Jefferson Post says, could the appellate's counsel reserve his time and offer it to let her dig herself a deeper hole? Well, he did reserve time, but it looks like they gave him that time anyway. So it's not really that big a deal. Looks like it worked out regardless. So he was all set. Jefferson Post again says, the first judicial train I've ever seen run on someone. Oh, buddy. There are, trust me, there's a lot of these. There are some really bad oral arguments out there. Like there's one where it's out of Georgia where Children's Services got caught committing perjury and they had done a bunch of really heinous shit and it got appealed. And the attorney had to defend the position and just got shellacked. If I could find it, we'll go over it because that's one where somebody's really getting killed. Eric says, I saw the video you just retweeted where the dumb cop jumped on top of a moving car and spilled off and cracked his head. Yeah. This is also where the New Orleans attacker is from. Oh, interesting. And it was in your hometown. Yeah, if you guys have not seen this, I thought this was bullshit. We'll just show this real quick. This is the... Let me bring this up here. Oh, hold on here, Chad. I need to fix something. Okay. So this is it's out of Beaumont, Texas, I believe. Well, anyway, here's what happens, and this woman gets charged with the injuries to the cop.
Oh, she's trying to run. Get in the car. Oh!
Yeah.
Free, look how she.
So look, watch her again. Watch it again.
Oh, she's trying to run. Get in the car. Oh! Oh shit!
And now they charged her with injuring the police officer, which is absolute horseshit. There should be some limit to what they can charge you with. It's not reasonably foreseeable the cop would basically just jump onto a moving car like that. It should be reasonably foreseeable. That should be the standard. And I don't believe it was there. So, Tony the Tiger says, all scholars, lawyers, courtiers, gentlemen, They call false caterpillars and intend their death. From Henry the Fourth. I'm sorry, Henry VI. Sorry, Henry VI. Yeah, I've heard that before. I've heard that before. Shakespeare didn't have a nice thing to say about lawyers. Stabby's been a member for 19 months. Thank you, Stabby, for the support, and it's always awesome to see those numbers. Thank you. Saying her dog must have eaten her homework, Sean. Yeah. Yep. And the Jefferson Post gifting 5 subs himself. 5 more, chat. Getting rid of the grays. Sorry, grays. We're putting greens in to take your jobs. Taking your jobs. Plea the Fifth says, can an Illinois resident just go to Indiana to buy their guns and ammo? No. You can't do that because you still need a firearms owner ID card. You can't get around that by going out of state. You cannot just get around that if that's what you're trying to cost or try to figure out. She's still writing. Yeah. Let me see. Judge Ziarman is looking hungry. Yeah. Oh, yeah. It should be a slam dunk, but it's Illinois. I know that's the issue, guys. Remember, trying to gauge your oral argument based upon how well it went, based off that, like, it's tough. That's a bit of a gamble because you think you may have done well and you're going to lose. I mean, it all depends on things here. So yeah, it's not over yet. It's not over yet. It's not over yet by a long shot. Cody Wilson, the notorious pedophile. Yes, that Cody Wilson. Runkles. Okay, good stuff. You ended up ordering in to be lazy. Well, that works too. I always think about dinner. Well, Runkle posted about dinner. Keno Casino is on in 38 minutes. Yeah. Remember, they also have their big opening, so the Feltoning is back. Yeah, well, that's there. Fruit Fly say to stop talking. I have a flight with my husband. Deviled eggs, sweet pickle for deviled eggs. Sweet pickles or dill pickles? You need dill pickles in a deviled egg, I think. I don't. You could do it with sweet pickles, but I wouldn't prefer that. I wouldn't prefer it. The Illinois Constitution is word for word the same as the U.S. Constitution with firearms. It is, but it doesn't count. It doesn't. They claim it doesn't count, but it's different. It's different here in the state of Illinois. So, yeah. Let's see. Yeah, he just got knocked the fuck out. Yeah, he did. Let's go. Brandon says, where is Clyde tied up? Why is this? Oh. That was weird. Where is Clyde tied up? I don't know. I'm going to see if I can grab him. If not, I'll have to go hunt him down here real quick. Hey, Clyde. Come here, buddy. You want another treat? Come here. Come here, Clyde. Come on, Bubba. Come here. Come here. Look what I got for you. I got some weed treats. Look what I got, buddy. Come here. I see you at the doorway. All right, chat. I'm going to have to go grab him real quick. I will be right back. All right, guys. Got him back in time for some dog ASMR. Oh, I thought I was going to sneeze real bad for a second. So, let's see here. I'm trying to catch up with everything you guys said. Yeah, they got a 25-minute opening. Yeah. What's wrong, buddy? Oh, are you going to sleep? Do you want to go to sleep? He's like, it's okay, buddy. Come here. Oh, he's tired. He's had a big day. Manny says, you want a model stream? Well, we may work on that a little bit tonight. We may work on that tonight in a little bit. And dill pickle. Well, you got to put pickles or pickle juice in your deviled egg. Yes. Clyde is not in the bathroom dungeon, confirmed. Is that my usual AFK stream? Yes. Yes, it is. Cat not Williams. Thank you, Cat, for being here. Gifted 5 more subs. Oh, more H1 green visas. Say bye-bye to your jobs, Grays. The Greens are taking them from you. And Clyde and the Greens are going to take your jobs. You okay, buddy? Do you want to lay down? Do you want to, take a nap like a baby? Is this better? Are you better like that? Is this better? Mwah. Clyde was arf ahooga. Yes. Yes, he was. Brandon says the Clyde kidnapping fund. I mean, to the luring fund. Yeah. I don't know what his deal is lately. He's had an issue about wanting to come in here. But like I said, there's other times where I'm just sitting here minding my own business, playing around. And guess what? He comes running in here to jump up on me. And he's like, pick me up, fat man. He puts his paws on me. At least that's how I assume Clyde talks. He's like, fat man. There, that's him. Oh boy, Clyde, I love you, buddy. Mr. Squiggle says Sean sounds baked as a kite. I bet he's been getting into the treats. Yeah, they don't smell good. Nice to see a loud tuber not begrudge his dog. Well, I love my dog. I love little friends. He's my little friend. He's a good boy. He's such a good boy. Such a good boy. So, look at that dog. Yes. Does Clyde like snow? Yeah, he likes to go and run around in it. But he's not like going into the big deep snows. Celeste Sims, how are you doing? Thank you for being here. You were stopping by. Did he like the multivitamins? He gobbled it up. The one I gave him so far. Oh, there's a Laurenator raid. Oh, okay. Gosh, hey. Thank you guys for being here. We just got done listening to oral arguments in the state of Illinois about the firearms owner's ID card and whether or not it's constitutional. Mike is saying, do I think that went better for the lady from the government since it was on Zoom? No, because she was going to get the same questions. I don't think it would have changed for her ultimately, really, if we're going to be honest. They would have had probably the same questions, and it probably would have been like the same thing no matter what. I don't think that would have changed for her, honestly, that much at all. I mean, it's probably better for her because, like, she's not driving home from the court like, oh my God, I got my ass kicked. Or you have to sit there and take it in person. You can just turn off your screen and go back to work or go have a cup of coffee. So it's always better. It's always better to get your ass kicked on the computer. Do I ever watch Vince Venturella? He has amazing painting and airbrush tutorials. Never heard of him. But does he have a channel? Because if he does, hold on here. Vince Venturella airbrush. We're going to take a look at this. Woo, this looks good. Okay, I like this guy already. He looks pretty dope. 148 Ks. Oh, yeah, he does miniature painting. Nice. All right, we'll take a look at this. We'll take a look at this guy at some point. No breastfeeding Clyde. Oh, yeah, well. So, and also, guys, if you, and Clyde stole the edibles. Yes, he did. And Clyde did steal the edibles. That's what he does. Let me see here. We'll just make sure I didn't miss anything. So, yeah, guys, that is it. I mean, I don't know how this is going to hold up going forward. I'd love to sit here and tell you, like I said, I'd love to sit here and tell you they got this in the bag, but it doesn't, it's never a sure thing. And Botto Entertainment saying, now I'm scared. Well, I'm just telling you the truth, man. My job's not to sit here and bullshit you. I'm just telling you the truth. I'm telling you how this shit goes. Nothing's guaranteed. Nothing's ever a done deal. Nothing's ever a sure thing. We'd like to see what happens, but also, prior experience does indicate what goes on there. So, did I watch the Tesla episode, or the Sean Ryan episode about the Tesla guy? Yeah, but there's some stuff Sean Ryan does that's a little like every once in a while he goes off at some crazy things that are out there. So no, I have not watched that one. He had like Sam Shumate on there, or Sam Shumat. I don't really. That one's kind of a nutbagger one to me. Sometimes Sean Ryan gets into that nutbagging stuff. So there's times where Sean Ryan is very, very tinfoil. And remember, Sean Ryan is a former glowy. He was a Navy SEAL for a couple of years, but then spent a majority of his career pulling triggers for GRS, Global Resource Staff. GRS is the same company that the guys from 13 Hours, when you watch that movie about Benghazi, that's where those guys worked. They worked for a CIA contractor that, provided, former tier 1 guys as, hired guns. So, as much as like Sean Ryan is fighting the good fight now, supposedly, he was a career glowy, and you have to keep that in mind. So just something to think about. He is a career glowy. Doing work for the CIA. I'm not talking, and it wasn't Special Activities Division. Different set of people. GRS was a company that hired and contracted things for the CIA. So. Yes, for 13 Hours. Yep. Former glowy, also current glowy. He could be very much still a glowy. Yeah. And he props up liars like Tim Kennedy and John McPhee. Yeah, that whole Tim Kennedy thing kind of fell apart. And it's funny because then McPhee tried to like jump in and he got torn down. So yeah, if you guys have ever looked into either Tim Kennedy or John McPhee, obviously Tim Kennedy is really kind of taking it up the butt hard for embellishing his service record. I mean, like he was a Green Beret, and he did get deployed before, but yeah, he wasn't as high speed as the guy who died in Las Vegas. Livelsberger, that guy was salty. That guy had a pretty impressive set of awards and commendations, but Tim Kennedy's was pretty boring. So, did you see the new Matt Gaetz show? No, not really. I'm not really interested in any of that. I assume it's not going to be very good. Like, all this shit is just kind of money grabs. No, because, I mean, what's Matt? He's like, I'm going to tell you things I couldn't tell you before. It's like, bullshit, you're not. Bullshit, you're not. Did I watch The Revenge of Lord Bald a lot yet? Yes, I did. I happened to be on when it popped up. I watched it. I'm very happy to see how. And the first 10 minutes, I was really sad. I was really like, oh no. But by the end, I was very thrilled. So, had a happy ending. Had a happy ending for me. And don't worry, we'll watch it on Monday night. We'll do it live and react then. Oh. Yes, Tim Kennedy did a TV show on the History Channel with that guy. I did see all those things out there. Gibeon says, what's a glowy? A glowy means you work for the government, like that you're glowing. The idea is that you're, a little bit like you intentionally drawing attention. You're a bit radioactive. You just glow. It's from it's from Uncle Terry when he used to make comments about the CIA having glow people. I mean, if we have to, I'll use this quote. This is from Uncle Terry. This is where glowy comes from.
The CIA niggers glow in the dark. You can see them if you're driving. You just run them over. That's what you do.
So there you go. There you go. Yes. Angela said, I ate a 50 milligram edible. Oh my God. That's a lot of edible to eat. Ooh. Ooh, that's a lot. Yeah, I showed him the video. Kami's glow. Yes, Kami's gonna glow. Yes, the Temple OS guy. Yes. Yes, God's at, God's programming. Yes, Angela, did he say the hard ER word, the hard R word? Yes. Terry Davis was very fond of using it. Although everybody got called that, so it wasn't just Terry. It wasn't just black people. Terry called everybody that. So that's a thing there. You only asked because you ate an edible and you couldn't move for hours. Yeah. Yes, Terry Davis was a god amongst men. And the thing is, Dankula does a really good review of him on Mad Lads. Count Dankula does a great job. Yes, most of what Terry Davis said, were always great art. Were great bangers. Everything he said. All right, chat. So that is it. Before we go, though, I want to talk about our sponsors tonight. Where are they? They disappeared. First of all, dragonstreasure.com, your haven for tea and anime lovers. 10% off using the code criminal. MAF-arms.com. You know them as Fudbusters, the premier wind chime dealer in all of South Central Florida. Use a promo code POTCRIM. You get 10% off there as well. Store-wide, and they are doing their Yuletide yard sale. So go over there and check them out, pick up some deals. And then last but not least, chat, Stoney's Bar and Grill at 158 East Broadway Street in Rockville, Minnesota. That's right, chat. Stoney's serving the area for 30 years. Your premier place to go. It's only 7 o'clock. Remember, chat, if you can get there by 8, you can watch The Unwanted, a band that's out there doing great work, and they are doing some great stuff out there. They were just at Stoney's a couple weeks ago, but they are doing that again tonight. Should check them out. You can see them over there, over at Stoney's in Rockville, Minnesota. With that, guys, I think we're almost done here. Fedorovsky said 7 o'clock. It's 2 a.m. Well, in the central time zone in Minnesota, it's only 7:18 p.m. Trump better bring back the $2 cans. Yes. Richard Gruber says, hey, I just tuned in. Can you restart the stream? I'm sorry. We will not do that. Yes, get the cans that April does not have over at Stoney's. Oh, yeah. Yes. So that is it, chat. That is it for us. We are all done. I know Kino Casino is starting up in a little bit. I will be going live. We've got some stuff to do on the model here, and I'll set up the stream, but we've got most of the model painted black, and we'll work on the accessories tonight, getting them painted up color-wise. But if you guys were wondering what I've done in the meantime, done a little bit of work on the bad boy. We've got a little bit of dust there. There we go. Got a little bit of dust. Got a little dusty on it, but we got the we got it mainly looking good, and we got the hull painted up, and we're looking pretty good on all that. No, do I have a couple of? Did I just see some white spots, or is that glare? Oh nope, I just saw some white there. That was on the camera. So we're gonna work on all those little pieces again. We'll probably get those painted up, and we'll just kind of stream snipe the casino tonight and just watch them. So yes, it's 8:18 in God's time zone. Yes, it is. Sadly, Stoney's is not closer because we would have been there already, chat. So don't huff paint. Oh, we're not going to do it. We're not going to do that. Dagenworth says, well, you need to watch everything. Well, no, you're not going to watch everything, but you're going to watch a lot of it. You're going to watch a lot of it. So how about that? How about that? God runs on EST. Yes, he does. And it needs to be done with the CARC paint that gives troops cancer. Yeah, that's funny. Believe it or not, the chemical-resistant paint that's on a lot of military vehicles actually is a carcinogen when it's applied, and it's toxic to the touch when it's wet. When it's dry, it's fine. But as they apply it, you need to have special gear on because it can give you cancer. Yeah, interesting, huh? Interesting. So, Clive was working on it off stream. Yes, he was. All right, chat. So I'm gonna, you know what I'll do now? I'll just set this up. We'll do a little bit of an earlier stream tonight, but we will do we'll do it like this, chat. All right, and I'll set this up for like 20 minutes from now, and we'll get into it. And that way I could switch you guys and send you over there. But that'll be the game plan. The casino will get started, and after about 15, 20 minutes, we'll get into it from them. So, guys, I also want to say thank you all last night for joining in with what was going on Danny On's channel over with everybody saying goodbye to Jeff. I do think that was a very, very fun time. We got to say goodbye to Legal Vices. And, guys, remember, it was all about, and like I said before, it's about remembering all the good times. You get to keep them, and they stick with you forever. So, with that, chat, once again, farewell, Jeff. We miss you. But also, for Gun Saves Lives, I wish them luck. I hope they're victorious in this ruling from the Court of Appeals. Just not holding out for it to happen, but we'll see. We'll see. And remember, chat, until next time, just because you can't answer questions from the judge doesn't mean you're going to win your case. So, good night, everybody, and take care. See you guys.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fat guy?